Hi there, my name's Carl Irwin. Who am I? I am the author of this channel, and I don't frequent the channel very much. I don't do a lot of creation on this channel. I haven't for quite some time, but occasionally I do create tutorials dealing with music composition and also dealing with production on Linux open source software, in particular Qtractor lately. I've done some work with LMMS. This is an offshoot of another channel that I had for years that dealt with Blender and content creation in Blender. These are side hobby kinds of things that I work on. I am a professional musician. I'm a music teacher, conservatory trained music teacher, also a composer. I'm a member of ASCAP as a composer and a publisher. I have licensed works and written symphonic works that are licensed. I've done some film score work years ago, have a couple of IMDb credits, so that's who I am. First time you're seeing me, I think, my face on this channel. I've not really had a reason to do a kind of face reveal because most of the content on this channel deals with screen capture and tutorials related to software. But I'm going to do a video here related to something that I noticed as I was doing a little bit more kind of upkeep research on sampled sound libraries that I use, in particular the Virtual Playing Orchestra by Paul Battersby, I believe is his name. I do not know Paul at all, but we're going to talk about his library and some commentary that's somewhat recent within the last few months on that library, particularly from a person by the name of Unfa. And if you've not been to his channel, I'll try to link this to the comments related to that video. He's got a great channel, as it would, I think, describes himself as a music producer, content creator, and deals with mostly synth-based content creation in also open source free software, and has a sort of a mission to use that kind of a platform in content creation. Very good channel. Highly recommend that you check him out if you're seeing me on here and you've not seen him before. But we're going to talk about some comments that he had related to this library, the Virtual Playing Orchestra. Before I get into that, I'll tell you a little bit more about myself. I also have a channel that really my big channel on YouTube. I have one that is I spend a lot of time on, is actually a close-up magic channel. My handle on that channel is The Common Magician. That is where that's my real hobby. Music is my profession. I do a little bit of it as a hobby concerning Linux and some of the stuff with Qtractor and LMMS, and I've kind of backed away from that as I've been more busy as a family man and a father. And my real hobby time is spent on the close-up magic side. I sell magical effects. And I bring this up because it's actually going to come into play in the conversation. There's a very close relationship to that side of what I do and this discussion, which is about copyright, and particular Creative Commons licensing with sampled libraries. So I'll draw some of those ideas into this and try to make some connections for people to consider. As always in these sorts of discussions, there is that caveat that everyone makes. They say, I am not a lawyer. This is not legal advice. I want to say I'm not a lawyer. This is not legal advice. But I also want to say, as the American that I am, everybody's a lawyer. Okay, everybody's a lawyer. The law is not something that is under what we call a fallacy of privileged information. Okay, anybody can read the law, anybody can understand the law, and at least in this country, anybody is free to make their case in court on their own behalf anytime they darn well please. So everybody's a lawyer, let's just say that. And everybody can speak to it and debate the law and interpret the law to a certain degree. That brings us into a topic known as arbitration, which I'll talk about in a little bit here as we get into the real topic. I don't want to get ahead of myself, but I just want to start off with that. I'm not a lawyer. This isn't legal advice, but at the same time, everybody's responsible for what they do, no matter what you're told. Your attorney can give you advice, but really you're the one responsible for the choices that you make. So we'll just put that out there. I'm not responsible. Can't be. It's you, right? Let's talk about copyright. As a content creator, I have a lot of things that are under copyright. I have music that's certainly under copyright. I have magic products in my magician side of what I do that's under copyright. I have Blender stuff that I created that was and was under copyright, and I've used different licenses. Some Creative Commons that releases those copyright. I tend to use the CC0 so that there's no. I just release all rights to, particularly in the Blender side of stuff, and with some of the music things that I do. With the magic stuff, I don't. The things that I sell, I retain the copyright to those, but you'll be interested to find out how copyright applies to a magical effect and the way that gets imported into some of these topics related to music and samples in particular. A copyrighted work, as you know, and I don't mean to insult anybody's intelligence, but copyright is applied the moment that something is created and affixed to a medium. That's how copyright works. It's not something you have to register for. You don't have to claim it. It exists inherently at the moment of creation and when something is affixed to a medium. It typically exists as it is affixed to that medium. If I make a recording of something, I have a copyright of that recording. There is some mechanical rights that are part of that. There is copyright that is part of the intellectual property that's on there, that is the actual music, the composition itself. Same with photography or any other kind of thing that can be affixed to a medium. Part of that interpretation of copyright does require that there is a creation of something that is not merely a raw material, but actually there is an intellectual component to the thing that has been made, right? I can't claim a copyright on a naturally occurring phenomenon. That's not possible. You'll be curious to know that in magic, in a magical effect, if I take a coin and I vanish it, I can't copyright that effect. I cannot copyright pushing a pen through a dollar bill, appearing to tear it and then restoring the bill. I can never copyright a phenomenon. That is not possible. It is not permitted under law. What I can copyright is the medium to which I affix that performance, so the video of it. I can copyright any teaching material that is affixed to a medium. I can copyright that, but I cannot copyright the phenomenon. It is not permitted. It is not ethical. Can't be claimed by anybody. You just can't own it. Can't own it. We're going to get into how that also applies to music here in a minute, in particular in sound in general, because some sound is a phenomenon. You can't really copyright certain parts of sound, but other parts you can. There has to be components related to it, though. Copyright applies to a work, right? Something that is a work. What is a work? Again, a work is something that requires various types of elements that are created by an individual, right? In the terms of music, a musical work has to be something that uses musical elements. A mere sound cannot be a musical work. You can maybe at an existential level claim that, but certainly not according to any copyright law. I'd have to have some kind of compilation of components, musical components, that make that a musical work. And this will get into samples here in a little bit, because when we say the word sample, particularly the producer side of it, I'm not a big fan of that term, producer. That's just my opinion. I find that producers, people that call themselves producers and they create music using samples and sets, you're composers. I mean, I think you're selling yourself short. You're really a composer when you get down to that. It's just that you're using a vocabulary, some of which is kind of already pre-mixed paint, I guess you would say, right? But a producer, typically they refer to samples, and I think there's a little bit of confusion about what a sample is, what it isn't, and how that word can be applied to multiple things that are not the same. We'll get to that in a moment. But a copyrighted work has to have a compilation of musical elements in order for it to be really something that is created and copyrighted. Let's see, where am I at here? I got a bunch of notes to follow. A synth sound cannot be copyrighted. You can't copyright a synth sound. A synth sound is a phenomenon of oscillators and filters. You can't really copyright that. You can't copyright a synth preset. Can't do it. Now, I know what you're thinking. You're saying, but people sell packs of presets and there's a copyright. How does that work? People sell patches, synth patches, right? And there's a copyright applied. What you have to understand is that the copyright in these instances is applied to the actual medium, the waveform itself, not the phenomenon of the sound, but the actual waveform is what is copyrighted. Okay? In this instance of the preset, it is the collection of presets, but not the actual settings. You can't copyright the phenomenon of settings of oscillators and filters, but you can copyright the actual data, the file data that is used and loaded into some kind of a plugin that the preset is for. That's what the copyright applies to. It is it's treated a little too abstractly, I think, by people, but you really do need to understand where the copyright lies and what it is in. And that's very important as we go forward and we talk about patches. Now, what this means is that if I have a patch of a synthesizer sound, a preset that I made or a synth, that I've put together, I can have a copyright on that patch as a file. What that means is that my file cannot be redistributed. That would violate my copyright. It doesn't mean that my patch can't be used musically. Okay, that doesn't. There's no limitation on that. I can't have a copyright on the musical use of a sound that I made. I can only have a copyright on the patch itself as a patch. The reason for that is because we get into the arbitration of copyright law. Okay, there is the law itself, which deals with something that is created, and then there's the arbitration of that law. Arbitration meaning the adjudication of how it is applied. When you get into arbitration, you end up dealing with subjects that are in the law, such as fair use. And a lot of people roll their eyes at that. And the term is grossly overused and mishandled. Let's just get that out of the way. But it is a factor of arbitration that really matters to copyright. Fair use, and as a subdivision of that, you have the concept of derivative works, which I think people think plays into this discussion about samples libraries. We'll talk about how it does and how it doesn't. But the concept of derivative works under fair use. And then the other one is the concept of transformation. Okay, that is the transformative quality of a work that is using something pre-existing that then separates it from that work. So the way fair use works is that, and by the way, these are not global principles. There's going to be some nuanced differences country to country, but I'm going to try to play it really, really safe here and talk in the broadest, most general terms so that people can feel, I think, this is my opinion, can feel secure using some of these libraries, okay? I just want to explain it in a way that hopefully, I think, objectively you will agree. Hopefully. And some of you may not, and that's okay. I mean, you can decide for yourself. I've decided for myself, here's why, okay? But when you're looking at the concept of derivative works, a derivative work is whenever you're taking something that is pre-existing in copyright and you're using major factors, major elements of that work and deriving a new work from it. And those major elements are intact, right? Somebody takes a picture, and then I use that picture as part of another work, and I derive from it, maintaining the major elements of that photograph. This is why it's in arbitration, because who says where you cross the line there? Right? That's for the courts to decide in a lot of cases. Or if you get permission, you don't have to worry about that sort of thing. This is very muddy territory. However, there is a concept of transformation, and that is where something has been altered to the point where it does not resemble its original state in any stretch of the imagination. It has been completely and utterly transformed. Okay, and this is a real legal principle related to copyright law and arbitration on fair use. Now, how does this relate to sample libraries? Let's talk about samples for a second. So there's a difference between a sound sample and a music sample. And this is where I think producers in particular kind of muddle up, can innocently, very innocently muddle up the term sample. Generally, a producer will talk about a sample as any piece of recorded sound. Makes sense, right? And in that sense, all samples are the same. However, when you're talking about copyright, they're not all the same. Because as I said, you cannot copyright a phenomenon. You can't copyright the occurrence of a trumpet playing in A. You can copyright a wave file that you own of a trumpet playing in A4 or whatever, okay? And your copyright is on that wave file as a sample, right? But not in the transformative use of that sample. It only means that that sample cannot be sent back out, right? Secondarily, as that sample giving credit to somebody else without attribution, whatever the copyright licensing, the Creative Commons licensing says, okay? You got to understand that, okay? There's a transformative property to it. Music samples, on the other hand, are different because the copyright does not apply to the actual file itself. It actually applies to the intellectual properties of the sample, right? A music sample actually has composition in it. It has potentially rhythmic qualities. It has orchestration qualities. It has, and all together, not individually, but all together. Okay. It has chordal theoretical qualities or pitch collection qualities, rhythmic qualities tied into those things. All these elements together make up a music sample. Whenever you're dealing with copyright infringement, particularly in music, 9 times out of 10, that's really what you're dealing with. It's the usage of these elements without permission and something that is under copyright. And you'll hear a lot of people talk about how, well, if it's more than 6 seconds or less than 6 seconds or 10 seconds, that's all baloney, right? That really, there's no hard, fast rule on that or some sort of allowance. You really cannot use a copyrighted sample without permission of, when I say copyrighted sample, I mean a music copyrighted sample. That is where the copyright is not in the file itself, but in the intellectual property of the sample, okay? When you're dealing with a sound sample, there is no such quality. There cannot be. You're dealing with a raw phenomenon. It's just nobody can place it there. So I'll take you back to the magic thing. If you know the magic duo Penn and Teller, okay? Teller has a famous magic trick that is a shadow kind of play where he's got a light shining on him and a shadow against a wall. And then there is a rose sitting there with some petals on it and some leaves. And he takes these clippers, these shears, and away from the rose, he clips. And on the shadow, it looks like he's clipping the rose. And he'll clip, and then a petal or a leaf will fall off. And that's the magical effect. This went into court in arbitration for copyright infringement because another magician was performing this exact same routine. Now, the issue there is that Teller cannot copyright the phenomenon of the effect. You can't. You cannot copyright telekinesis. It's too broad. It's too big, right? It's a phenomenon. What he did copyright and where the actual case was at was in the pantomime of that effect. That's what he owned. He owned choreography. That is the intellectual property. That is the art form. That is the artwork. He had to add to it intellectual decision-making that made it his own occurrence. Okay? So it goes with music. You cannot copyright a pitch. You can't copyright a chord. You cannot copyright even in instrumentation. You can copyright music that has a conglomeration of components that make it musical in any length. You can copyright a wave file as data, used as data. You can do that. You can have ownership over that, and you can put licensing on that. but you cannot copyright the phenomenon. And then if there's a transformative quality to it that makes it something entirely different, all bets are off. You're well outside of any kind of rights that you can claim on it. Okay, so you got to remember that there's sound samples, then there's music samples. These are two very different things. They apply to copyright law in very different ways, and the law is applied to them at different levels. One is actually on the intellectual property, the other one is actually on the data itself. Okay, so keeping that in mind. Now, the use of a sampled sound in music is non-derivative, but transformative. Okay, so when you take a sound sample from a library and you use that in a sequencer to make to create a virtual instrument, that is entirely transformative because the sound sample does not exist as the sample anymore. Now you have a musical piece that is a completely transformative event, right? It's no longer an A on a trumpet wave file. Now it is transformed into a musical piece. Okay, it is far removed from that. So how does this license apply to it, right? Now, again, just to go back, if I use a sampled music, that is derivative. That's a derivative creation. That's derivative work. If I take a sample of music and I use it in a music composition, that's derivative work, and I'm under copyright because I'm dealing with the intellectual property. Okay, there's an intellectual connection to the musical work. That's where the copyright law lies, is in the actual musical elements of it, and that's derivative work. It might be transformative, but this is up to arbitration, and honestly, you never want to be there. You don't ever want to take that risk. You don't want to have a court case. You don't want to have to make a case for that and try to defend yourself. If you're going to be using music samples, you should be getting permission, or you should be using things that are in the public domain. Okay, sound samples, again, it's just you can't claim the kind of rights that people do. When someone claims rights on their sample library, it's on the library. It can only be on the library. It cannot be on anything else. There's just no way to make a claim because it isn't a musical work. Right? It's not a photograph. It's not even really a phenomenon. It's an organization of files, right? And any other change to that, and this is where the Creative Commons licensing applies in terms of derivative work, that is the alteration of that library as a library. That is where the copyright restrictions lie. If a Creative Commons license is applied to it that requires attribution, it can only be in that non-transformative use of those sounds. Hopefully you understand this, okay? Non-transformative use of the sounds. Okay, so that means that when someone applies their license that requires attribution, or if it requires attribution and it requires that the licensing continue on with it, so that whatever is licensed here has to be licensed on the new work, that can only apply to the non-transformative work, derivative work. So the use of it as a sample library in another sample library. Let's look at Paul Battersby for a minute. So on his website, what he does is he lists his sources. This is before any of this kerfluffle, before any of this stuff ever came up. He lists his sources, and in the sources, it had the attribution. Okay, Paul is totally covered. Totally covered. So when it comes down to what Paul has posted on his website, he has covered all of the bases. Now let's look at some of these licenses real quick, because there's a couple of differences in there. You have CC0 for a couple of them, right? You have some where there is no reference to Creative Commons. Now, there is, I think, a misunderstanding that the Creative Commons application is somehow a superior way to attribute licensing. Let's not think that way. Creative Commons is really something that's just frankly made up for convenience. Okay, that's what it is. So that a content creator can say, well, I choose this license, go read the license, that's how it applies to my work, and I relinquish my rights up to this point. Okay, and you cannot revoke it. That's something you have to understand. Once you've released rights on something, you cannot revoke it. That's only fair. That's how the laws work. So if I put a CC license on it, no matter which kind, whatever I release in my rights, I cannot claim them back. Once I've done it, it's done permanently. And as long as that exists with that license out there, people can do whatever they can within the rights of the license. One thing that's probably worth mentioning right now is that this is different from an end user license agreement, which I think was kind of conflated a little bit in the discussion, that when you purchase proprietary sound sample libraries, there's often an end user license agreement. This is not pertaining to copyright. This is a different licensing agreement. Copyright licensing has to do with the ownership of something. That's what it is, okay? Whereas an end-user license agreement has to do with the use of something, and that's more in the civil law rather than in the copyright law. So you'll have like something like East-West, symphonic libraries out there, and they might have an end-user license agreement that says something to the effect, and this has been debated a lot in forums and whatnot over the years, but it might have something to the effect of you cannot use this, or you cannot use this library for any music that you do not create, right? And the reason why they have these really funny, ambiguous, lawyery kind of, terminology in there is because they're trying to sell a product. They don't want to sell a product and then have people share it. They're trying to put an end user license agreement in there that legally protects them and prevents users from sharing the product with other people. It's not really about using copyrighted or non-copyrighted work and using the samples on those works. The end user license agreement is about ensuring that you are the one using this library and you're not lending it to other people. That if someone else wants to use our library, they need to buy their own copy. That's what that is about. Okay, and that's why you see those end user license agreements. Again, civil law, not copyright law. Unfa made a comment in there that really actually, I think, inadvertently hit the nail on the head. He said something about with these proprietary software companies that make these sample libraries, that they don't retain these rights for you to require attribution or to claim rights of your composition, because that would be ridiculous. That's exactly the point. That's exactly the point. That is ridiculous. That's why it can't be lawful. It's not part of the law. Nobody can actually do that. You can't do that with a sample library. You can't do that with a phenomenon. And that is why they don't do that. It's not because of any kind of end user license agreement or because you paid for it. They could give that away for free and it would still be the same copyright and the same license. The copyright applies to the product itself in its form, and any kind of non-transformative derivative, non-licensed derivative work, right? But it wouldn't apply to using the sampled library for its intended use, which is as samples for music, right? As sound samples, not music samples, but sound samples. Difference in where the copyright lies. Okay, now that gets us back to what a sample library is for. And this is a point I was trying to make on the forum discussion here, or not on the forum, but on the comment section under the video, is that when you're looking at a sampled library that somebody makes, it does matter that you account for what it is and what its purpose is, right? A sampled library has a self-evident purpose and use. The self-evident purpose and use of the sampled library is to be used for virtual instrumentation. That's the reason why it exists. It's a self-evident truth, right? There's no license that has to be created that says who can use it for what. Again, that can't even be copyrighted because of transformative, principles in copyright law. You just can't do it. It's not ethical to do it. You can't claim that. It just doesn't. It's not your. It doesn't belong to you, right? You can't claim someone else's intellectual work because of the phenomenon that you recorded as a raw sound. It's just not available to them. What they can claim is copyright via attribution of derivative work of what it is as a product, which is a sample library. Okay, that's what this is all about. And again, it comes down to these principles of arbitration. Now, some of you will look at this and say, I don't buy that. That sounds fishy. Well, it's the truth. It is. This is how it works, right? I would also bring up that Creative Commons licensing does not supersede the creator's rights. And that is made perfectly clear on the CC websites, right, on their information. When you're looking at licensing, if you look again back at Battersby's sources, some of them have CC licensing. Some of them have other things on them, right? Like if you go to the University of Iowa website where he used those sounds, and on there, and Unfa kind of picks fun at this, but I have to say that their license is actually the best one because it's specific. It's specific, it's by them, and it has a very specific, very clear directive. And the specific clear directive is that these sounds can be used for anything, period. That's the license. It's their sounds, they recorded them, their library, and you can use the sounds for anything, period. You can redistribute them, you can use them for anything. There's no reason to give any kind of attribution at all. Someone could say, well, that's a CC0 license, but it isn't. Like, who cares about Creative Commons licensing? This is a serious view of licensing, by the way. Don't think this is unserious. Okay, I'm quite serious about this. The most important licensing is the one that someone gives in whatever words they want to give it, right? I would recommend not necessarily taking one of the Creative Commons licenses for any kind of work you do, but just, quite frankly, state your wishes. And let that be your license. Now, the claim here is that the CC licensing is there for convenience. I get that. That's true. Absolutely. Right. But the clearest license you can give is one where you explicitly state what it is and what can be used for and what it can't be. And that's what it is. So the University of Iowa, those sounds were on there. They can be used for scientific purposes, which is some of what they use them for. They can be used for virtual instrumentation. They can be used for anything, anybody, anywhere, anytime, for whatever. That's it. And that license, again, doesn't apply to intellectual property like music creation, content creation. It applies to the WAV files themselves. That's where the copyright lies. It's in the library. It's actually in the library. There's another example on there of some sounds, and he gives a screenshot to demonstrate it, that they are all public domain CC0 sounds, and that's verifiable. So between all of these licenses that are on there, he really needs nothing else. It's perfectly good to use. He needs nothing else. He needs to point to nothing else. The transformative properties of arbitration and copyright law concerning derivative works, it's all covered. It's all covered. Paul goes a step further, though, because coming back to this idea that CC licenses do not supersede the creator's wishes except for when they give rights up. And you can't revoke those. You can't take it back. A content creator can always edit their license and add more to it, right? They can't restrict something that's been unrestricted, but they can certainly unrestrict things that a CC license previously had restriction on. Anytime they want to. They own it. They're allowed to do that, okay? And they can do it by any means, even in an informal comment on a forum. That's sufficient. That is licensing. If it can be attributed to them, if it follows them, there's even some laws on this, at least in the United States, regarding electronic signatures that date back to the 90s. That when someone states something, even in electronic form, that is as good as signature, right? Again, this is all unnecessary. We don't even have to talk about this as far as the licensing works and whether or not these are usable legally to create music. But he goes that extra step there on the webpage because of all of this discussion. And he says, look, these are conversations with the people that made this stuff. And case in point, if you go to Matthias Westland's Sonatinas sounds and some of his other ones there, his website for years before this ever came up pointed to VPO as the place to get his sounds. That's a direct forward from his own website, is VPO. This is where you can get my sounds. I don't even have the sound font anymore. Just go here. This is where it's at. This is better. This is where my sounds are applied. Likewise, and I know Unfa has on his on the video there in the description, there is a link to some verified CC0 sources. One of them is the Brazilian Studio Community Edition, chamber orchestra. That's a curious one, because if you go to the website that is on that list, do you know what you find? VPO. That is what they credit as a source for their library directly, right? And that's what Paul is alluding to. He's saying, I don't know what this is about. These people point to me as the resource for their libraries directly, right? Where that is required, and it's really not required because he lists the license, right? If you're really going to be truthful about this, you have to take the Brazilian Studios Orchestra off your list because of that direct connection. Now, there's no reason to do that because Paul's covered. Is it a CC0 license? No. Does it really apply to content creation in terms of music? No. Does it apply to repackaging and distribution of sound libraries? Yes. That is where the copyright is applied. That's what this is about. Okay. Yeah. So the best license is the one that someone gives directly in their own words, right? That's not inferior to a CC license. It's superior, really, in many ways, because it's highly specific. Even if it's written in crayon on a napkin, right? That's really the serious view of licensing. A person's, the person stating their wishes in their own words, rather than putting a kind of a blanket explanation for their wishes on it by using a CC license. Those CC licenses are very useful. Like I said, I did some Blender work where I made some models, complete compositions. Again, this is kind of the application here. I had a building pack I made years ago that was in OpenGL that you could find on BlendSwap. And it was these, skyscrapers. It's still out there. I actually saw it pop up on a news feed that hit my Google News feed on my phone just a couple weeks ago. I said, oh, there's my models, right? They're on there. Someone used it for some kind of an art. They were talking about, what was it? They were talking about a solar flare and, affecting the power grid or something. And they had an animation of the lights going out in the city, and they were my models from BlendSwap, right? And they were free to do that. I gave it up. I gave them up, right? Now, I could have applied some other license to it that would have required credit. And that would have been applied because the model exists as the model. It's not a transformative application. You could put it inside of a city, but it's still a building, and it's still my building. Okay? It's not a raw creative work. Or rather, it is a creative work. It is not a raw material. It's not a phenomenon. I've applied texturing to it. I've applied geometry to it. I've applied lighting to it. I've baked in the shadows. I've done everything, right, that applies it to my, that identifies it as my creative piece. It has all of my fingerprint on it in creativity, and my copyright is on that until I relinquish it as CC0, which I did, right? Certainly don't regret it. I'm happy to do that. It could be now not only used in artwork, because it is a piece of art, in derivative artwork, but it could also be redistributed as a building pack by anybody else. CC0, right? And that applies in that way, but a sampled sound can't fit that bill because it's not a creative work. It is a file. It is a data, right? There's no creativity in a note on an instrument or on oscillators. People may disagree with that, but there's got to be a line. You cannot copyright phenomenon. You just can't do that. It's not permissible by most copyright laws. Certainly not by U.S. copyright law or most any other global interpretations of it. So anyway, that's my case there. Can I recommend that you use Virtual Playing Orchestra? I suppose I can. I use it. I have no problem. The licensing is clear. it's covered. The application, if you understand the law, it does make very good objective sense. And his attribution is correct, and it always has been. He didn't update it in such a way that improved it. The original attribution was absolutely spot on, right on the money. The problem here is the third-party interpretation of what the license is supposed to be, and I think it's an error. One last comment on this, just a kind of food for thought, 40-minute video, but it's worth talking about this stuff. Hopefully this has been interesting to you. Maybe you're coming along with me. Maybe you see issues with my argument. Go ahead and leave some ideas in the comments about where you're at on this. But I'm pretty confident in my argument here, given my experience with copyright in other places. One thing that is important to keep in mind related to this is that I don't have any skin in it, and neither does Unfa. And I'm not directly arguing with him. Like I said, I love his content, love his channel. I highly recommend it, right? But we are third parties to it. There is the principle of proving a negative, which is an impossibility. You can't prove a negative. It is a fallacy, right? The negative to be proven is that there is not a case, that there are no cases against Paul concerning this. I can't prove that. But the burden of proof is on, in this argument, if there is a contest, the burden of proof is on those who would say that there is contested usage. And Unfa can't prove that. He can't make that claim because he's not party. He's an outside observer. The only ones that can make the claim are the original creators. And as it goes, those that are not licensed in the public domain, all of those creators have endorsed his project. There's no contest. So I would classify this as a war with no enemies. That's what this discussion is about. It's a fabrication of a war with no enemies, an application of theoretical copyright that I think is being misapplied to content and to material, right? So last recap, if you're going to make sampled libraries, you have responsibilities to use proper attribution where you can, or to only use sources that are in licensable open public domain or licensed to you to use with appropriate attribution where indicated in copyright law. When it comes to sampled libraries in music creation, if you own it, you are free to use it and make music of any kind, commercial or otherwise. That is not what the license applies to. It's just not, it's not within the scope of that license application. The license applies to the medium that it is, not to some transformative thing that it cannot be and is not in its state. Okay. Good luck with that. Happy mixing.